Sixth case from supplementary list and ready for admission item 3 WPS 1265 of 2023.
WPS number 1265 of 2023. Heard the learned counsel for the parties. This writ petition has been filed seeking a mandamus upon the respondents to regularize the services of the husband of the petitioner notionally from the date of recommendation made by higher authorities or from the date from which his juniors were regularized. In regular/permanent post, since the deceased employee had already served more than 25 years and died in harness while serving the respondents when he was deployed as a polling officer in parliamentary election 2014. The husband of the petitioner died due to terrorist attack. A further direction has been prayed for to pay pension and gratuity from the date of death of the husband, that is Amit Kumar, the foundational facts of the case is not in dispute. On 10/7/1989, the husband of the petitioner was appointed, the husband of the petitioner joined the office of Deputy Director, Regional Dairy Development Office, Dumka, Department of Animal Husbandry and Dairy Unit, Dumka, on the post of stenographer on ad hoc basis. On ad hoc basis, and he worked against vacant sanction post of stenotypist. A letter of recommendation for regularizing his services was issued dated 28/4/1990 and on various subsequent dates and one such letter is dated 14/4/1998 issued by Assistant Director to the Director for regularizing his services. It is not in dispute that the husband of the petitioner continued to work, though on ad hoc basis. And even in the year 2014, he was working, and on 10/4/2014, he was appointed as polling officer for general parliamentary election to 2014. And while on duty, he expired on 24/4/2014 on account of extremist attack, and by this time he had already served the respondents for a period of 25 years. Even after his death, a letter dated 6/6/2014 was issued by the respondents for his transfer, mentioning therein that he was working in as grade 3 employee, correct? Please verify. If you have any issue, please let us know. It is further not in dispute that since the husband of the petitioner died while performing his duty as polling officer, an amount of rupees 20 lakhs has been paid to the petitioner by way of compensation as per the scheme.
As per the scheme of
As per the scheme of the respondent.
As per the scheme of the central government.
Achha, as per the scheme of the central
Because he
government.
was working as an electoral
Okay.
polling officer.
Fair enough. It also appears from the records of this case that even after his death, letters dated 10/12/2015 and 5/4/2016, 10/12/2015, 5/4/2016, 6/4/2017, and 11/9/2017 were issued for regularization of his services, as the petitioner has been pressing hard for payment of post-retirement benefits. However, when no decision was taken, the present petition has been filed. It has been stated by the writ petitioner that her husband was being treated as a regular government employee, inasmuch as he was not only paid salary from time to time, but was also transferred during his service tenure as per the requirement of the respondent department. And these facts, as stated in the writ petition, have not been denied by the respondents in their counter-affidavit.
And he was been given the pay scale of 5200 to 1,200 and rate pay, that is at page number 68 here, of the petition. They have prepared a seva sampusti hetu charge per
The learned counsel has also submitted that even service book of the petitioner, of the husband of the petitioner, was prepared and appropriate entries were made regarding his posting and pay scale. The petitioner has made specific statement in para 11 of the writ petition that junior to the husband of the petitioner, namely Tarun Kanta Topo, who was subsequently appointed, was also regularized
she is Tokno.
Tokno, yes, Tarun Kanta Tokno was also regularized, though by virtue of judgment passed by this court in WPS number 981 of 2020.
Only on this point I would like to show you.
The order of regularization of Tarun Kanta Topo has been also brought on record as contained in Annexure 4 dated
9 of December 2020.
dated 9th of December 2020. This is not the order actually. Has also been brought on record by referring to Annexure 4 of the writ petition. It is the case of the petitioner that the respondents, having taken work from her husband for more than 25 years, on ad hoc basis, more than 25 years, and having throughout treated her husband as a regular employee, but no formal order of regularization was passed, and while on duty, he ultimately expired on 24/4/2014. And therefore, the junior to the husband of the petitioner, though regularized subsequently, will not, the junior to the husband of the petitioner regularized subsequently entitles the husband of the petitioner to similar benefit notionally, so that the petitioner would be entitled for post-retirement death cum retiree benefits. She has also submitted that there has been no complaint or complaint with regard to the work of the husband of the petitioner. The learned counsel appearing on behalf of the respondents by referring to the counter affidavit. The learned counsel for the petitioner has referred to the judgment passed by this court in the case of Vishwanath Sharma versus State of Jharkhand, within bracket annexure
6.
नहीं ऐसे इसको से the learned counsel has referred to the judgment passed in the case of Tarun Kanta Tokno Supra and has submitted that he was granted the same relief as was granted to several persons whose name were mentioned in annexure 13 and 13 by 1 of the said writ petition. She has referred to internal page 3 of the said judgment, wherein 4 persons, namely Noble Kashyap, Prabhat Kumar Sinha, Buddhadev Asur, and Buddhadev Asur were confirmed in their service by order dated 27/6/2011 and order dated 25/7/2013 by the state of Bihar. The learned counsel submits that the order denying regularization of service of Tarun Kanta Tokno was quashed by this court. The order dated 23/4/2019 was quashed by this court and respondents were directed to confirm his services as was done in the case of persons who were appointed along with him as contained in annexure 13 and 13 by 1 of the state writ petition by the state of Bihar. The learned counsel has submitted that specific statement to this effect has been made in paragraph 11 of the writ petition, but the same has not been denied by the respondents in their counter affidavit. The learned counsel has also relied upon the judgment passed by the Honorable Supreme Court in the case of Narendra Kumar Tiwari versus State of Jharkhand. By this court in the case of Narendra Kumar Tiwari versus State of Jharkhand in WPS number 6347 of 2018, and has submitted that it was observed that even those persons who had worked for more than 10 years and had retired during the pendency of the writ petition were also entitled for regularization from retrospective date. These two judgments should be sufficient? Nay, the learned counsel has also relied upon judgment passed in the case of Vishwanath Sharma, WPS number 2183 of 2019, and has submitted that he was also appointed as back as on he was appointed as back as on 7/11/1983 as bill clerk cum cashier against sanctioned vacant post, and his services were extended from time to time, and he also retired from service.
And after
And after
retirement, his services
his retirement, considering the fact that he had completed more than 23 years of service, his services were ultimately directed to be regularized with all consequential benefits.
specific judgment of Punjab and Haryana court is there in relation.
The Learned Counsel has also relied upon the judgment passed by the Honorable Supreme Court in special leave to appeal with bracket C number 1109 of 2022, and has submitted that in a case where the original writ petitioner had put in 30 years of service on ad hoc basis, the Honorable Supreme Court was of the view that the retirement benefits, of the view that
Pensionary
pensionary benefits could not be denied to such a person. The Learned Counsel has submitted that no reason is reflecting from the counter affidavit for not considering the case of regularization of the husband of the petitioner in spite of repeated recommendation from time to time. That's it. The Learned Counsel, appearing on behalf of the respondents, has opposed the prayer and has submitted that an ad hoc employee, even if continued for a long time, is not entitled for pension, as the condition precedent for grant of pension, that the employee should be a regular employee, is not satisfied. The Learned Counsel has also submitted that the conditions have been prescribed in Rule 58 of Jharkhand pension rules, and that the three conditions have been prescribed. First, the service must be under government. Second, the employment must be substantive and permanent. Third, the service must be paid by the government. The Learned Counsel submits that condition number 2 is not satisfied. The Learned Counsel has further submitted that so far as the case of Tarun Kanta Toppo is concerned, though no specific reply has been given with regard to para 11 of the writ petition, but on facts it is distinguishable in as much as he has been regularized after the death of the husband of the petitioner. यही बोलना है?
He was continuing in service when his services were regularized.
And he was still in service while his services were regularized.
And secondly, at page 34, so far as this, since she says that they were also appointed by the same letter, the petitioner was appointed as stenographer in the regional, page 34.
34?
34.
Yes.
The petitioner was appointed as stenographer in the Regional Dairy Development Office, Ranchi, by Dr. 29/7/1990 on ad hoc basis. Subsequently, the appointment was extended for 3 months by order dated 20/10/1990 and time to time. It was extended by the office order contained in Annexure 1 series. By the order dated 18/10/1993, the Director Dairy Development Directorate, Bihar, Patna, directed to the Regional Joint Director Dairy Development, South Bihar, to make appointment of the candidates due process on sanctioned vacant posts. Pursuant to it, a selection committee was constituted, and after deliberation, the committee has recommended that the name of petitioner along with the others for the post of typist clerk, while selection committee proceeding dated 28/1994 as contained in Annexure 3. So their name was recommended by the committee, and whereas this petitioner was also working at that point of time, but he continued on an ad hoc basis only.
But they also continued on ad hoc basis only.
They continued on ad hoc basis, but their name was again recommended against sanctioned vacant posts. And so far as this petition is concerned, the recommendation letter of 1990 that you will see.
At annexure?
9, same line. Page 58.
Page 50?
8.
उल्लेखनीय है कि कुमार आकस्मिक कर्मचारी होने के नाते उनकी मजबूती योजना समिति आकस्मिक मत से भुगतान किए जाने के कारण कार्यालय में के अन्य कार्य संपादन एक तरफ निधि के कमी महसूस की जा रही है, वहाँ दूसरी तरफ स्वीकृत पद रिक्त रहने के फलस्वरूप उनके वेतन आदि भुगतान के लिए उत्पन्नित राशि बिना खर्च के प्रत्यक्ष किया जा रहा है. That means he was continued to be on whether he was appointed on a sanctioned vacant post or not.
There was a sanctioned vacant post, it is mentioned here.
It was available here.
That is sufficient. Otherwise, he would have been appointed against a sanctioned vacant post. The Learned Council has submitted that so far as Tarun Kanta Topu is concerned, the fact regarding his case has been mentioned in internal page 2 of the judgment, which indicated that he was appointed on ad hoc basis in Regional Dairy Development Office, Ranchi, by order dated 29/7/1990. His appointment was extended for 3 months by order dated 13/10/1990. And by order dated 18/12/1993, the Director Dairy Development Directorate, Bihar, Patna, directed the Regional Joint Director Dairy Development, South Bihar, to make appointment of the candidates due process on sanctioned vacant post, and pursuant thereto, a selection committee was constituted, and after deliberation, the committee had recommended his name along with others for the post of typist clerk by its selection committee proceedings dated 28/2/1994, and that he had also cleared the examination of first and second paper prescribed for Musaffil office in view of memo dated 23/7/2011, and the pay scale was also fixed, which was revised from time to time, and subsequently he was allocated Jharkhand capital. The Learned Council submits that on account of the aforesaid facts, the case of Tarun Kanta Topno is different from the case of the petitioner. She has also referred to the initial appointment letter of the petitioner to submit that though a post was post of typist cum clerk was vacant, but still the husband of the petitioner was appointed on ad hoc basis.
So with regard to writing examination, letter dated 6/4/2017, the recommendation has been made. Page number 67 states that page number 69.
Please hold on, just a minute. Page number?
16. Letter dated 5/4/2016.
In response, the learned counsel for the petitioner has referred to letter dated 5/4/2016 within bracket page 69 of the writ petition to submit that, yes,
Yes, Your Lordship, if I can read. In between para 1, विदित हो कि अंशु टंकन को बिहार सरकार राजभाषा विभाग बिहार पटना के पत्रांक 1785 डेटेड 1/10/1996 के द्वारा हिंदी टिप्पणी।
ये आपका पेज नंबर टैली नहीं करता भाई, मल्टीपल पेजिनेशन से बहुत परेशानी है। Almost at the middle.
हाँ, last 3 lines of the para 1.
Yes. The learned counsel has to submit that a letter number 1785 dated 1/10/1986 was issued
के द्वारा
which exempted the typist from passing the departmental examination. यही है?
and further the recommendation was made for the confirmation of services. The last line, अतः अनुरोध है कि ईश्वरीय कुमार का सेवा संपुष्ट किया करने की कृपा कीजिए।
She submits that by the said letter, the arrear of payment with regard to other dues of the ex-employee were sought to be paid by referring to different dues, and a recommendation was again made for regularizing the services of the ex-employee. She has also submitted that the detail with regard to the services of the husband of the petitioner has been mentioned in page number 68, which was prepared by the respondent on 10/12/2015. यही है ना पूरा background, right?
Yes.
You come to page number 60. Yes, respondent. Page number 60. Wherein it has been mentioned that after interview, his case will be considered. And if he does not succeed in the interview, he will be discontinued. But you never discontinued him. Nor you have mentioned whether what happened to his interview. How do you expect this widow to know about it? Right? After hearing the learned counsel for the parties and considering the facts and circumstances of this case, on account in view of the undisputed document as contained at page number 68, dated 10/12/2015, it is apparent that the husband of the petitioner was appointed as typist in तुमका क्या बोलेंगे कौन what is it? What would be the translation? 1992 क्यों बता रहे?
Anshu. It's not typist, it is Anshu, stenographer.
Yes, okay. After going through the records of this case, this court finds that the aforesaid factual aspects which have been recorded above and is borne out of the writ petition is not in dispute. However, for the purposes of confirming the regularizing the services of the husband of the petitioner, some details have been mentioned in page number 68, which refers the date of appointment of the husband of the petitioner as typist as 1/11/1992. He joined on 1/11/1992 and completed 21 years, 5 days, 24 days. In grade 3 was drawing a salary at the pay scale of 1320-30-1560-40-2040 and was also given revised pay scale in the scale of 4000-1000-6000, 5200-20200, grade pay 2400, basic pay 10,050.
That would be 4,000-100.
4,000-100-6,000. And he worked as typist for the period 1/11/1992 to 24/4/2014. The records of the case reveal that the petitioner, the husband of the petitioner, continued in service, but no order of regularization was passed. Although he was treated as a regular employee inasmuch as not only he was granted pay as per on the pay scale fixed by the government, his service book was also opened and he was transferred to different places under the direction of the respondents. It further appears from page number 60 of the petition that one memo dated 27/9/94 was issued, wherein it was mentioned that the husband of the petitioner was to be interviewed for the purposes of regularization and his services were extended for a period of 3 months, for a period of 6 months, and in case he becomes unsuccessful, his services would be discontinued. The respondents have not brought on record as to what happened to the interview of the husband of the petitioner. However, the fact that he continued in service till 2014 is not in dispute. This court is of the considered view that the husband of the petitioner, having worked for
$25.
25 उनका एक जगह 21 years भी आया।
The appointment letter is there 89 appointment letter.
For about 25 years, and that his junior, namely Tarun Kumar Topno, Tarun Kant Topno, who had also worked who was appointed after the husband of the petitioner, was subsequently regularized, though by the order passed by this court in WPS number 981 of 2020, by referring to the other persons who were regularized in service way back in the year 2011 by the state of Bihar. 2011 and 2013 by the state of Bihar. This court finds no reason to deny the same relief to the husband of the petitioner notionally, in order to notionally from the date as was done in the case of other persons, namely other persons whose name were contained in Annexure 13 and 13/1 of the writ petition filed by Tarun Kant Toppo. This court finds that said Tarun Kant Toppo was granted the relief by this court in the following manner. Quote करना है. As a cumulative effect of the above discussions, the impugned order cannot be sustained in the eyes of law, and accordingly, impugned order dated 23/4/2019 is quashed, and the respondents are directed to confirm the services of the petitioner, as has been done in the case of the persons who have been appointed along with petitioner as contained in Annexure 13 and 13/1 by the state of Bihar. The petitioner shall be entitled to consequential benefits. Good stuff. However, it is made clear that this order of regularization of the husband of the petitioner is being passed will carry no consequential benefits in terms of arrears of salary, etc. But as a consequence of this order, the pay scale, as a consequence of this order, the petitioner would be entitled for post-death benefits of her husband.
From the date of his death.
Sorry?
From the date of his
From the date of his death.
Of the expectation.
The needful be done. Who will do it?
second.
By the respondent number 1. Follow-up orders be passed by respondent number 1 so that the post-death benefit to the petitioner is remitted to her account, is granted to the petitioner within a period of 4 months from the date of communication of this order. 1 महीना NPA के लिए, 2 महीना stay के लिए. So this is how it is. It will have some improvement. I will quote a few paragraphs of the judgment, but this is what the operative portion will be. वो उमा देवी वाला जजमेंट शायद हम नोट करें.
From the daily list, item 15, WPS 1266 of 2023.
This matter pertains to promotion from the post of clerk to head clerk relation. The juniors to the petitioner has been given the promotion, and the case of the petitioner.
When and who?
Although they have filed 2 IAs, one for
One is for
withdrawing the counter affidavit,
and supplementary
and
affidavit.
second is for extension of time to file counter affidavit.
Why do you want to withdraw the contract?
Your Ladyship, in IA number 3155 of 2024, we have filed for withdrawal of counter affidavit as in paragraph 5 we have stated that the answering respondent number 3 had filed counter affidavit and supplementary counter affidavit. After the order of the High Court, we have asked to comply the order whether the Annexure 10 of the writ application was in accordance with the current status of this case. After the endeavors to seek necessary information from Department of Personal Administrative Reforms and Rajbhasha, Government of Jharkhand, the civil surgeon, the respondent number 3, has found that it has been wrongly stated and in the counter affidavit. So we have filed the IA for withdrawal of the counter affidavit, also for extension of time in 3143 of 2024, where Your Ladyship we have paid for 8 weeks time, as the meeting has to be conducted between the Department of Personal Administrative Reforms and Rajbhasha.
Where is that IA? One is IA number 3143.
315, one is 3143, that is IA for extension for time.
And 3155 is?
That is for IA for withdrawal of counter affidavit and supplementary counter affidavit filed on 12/9/2023 by civil surgeon, that is respondent number 3.
Your Ladyship, before that the last order of this court may be seen.
Okay. IA number 3155 of 2024. With IA number 3143 of 2024 in WPS number 1266 of 2023. The learned counsel for the respondents has submitted that IA number 3155 of 24 has been filed to withdraw the counter affidavit dated 2/5/2023 and supplementary counter affidavit dated 12/9/2023 filed on behalf of respondent number 3. He submits that error has crept in filing the state affidavits and the true position with supporting documents is required to be brought on record in consultation with the Department of Personal Administrative Reforms and Rajbhasha, Government of Jharkhand, for which a meeting is to be convened shortly. He submits that fresh counter affidavit is required to be filed on behalf of all the respondents by respondent number
2, 3 and 2. Respondent number 3, civil surgeon cum medical officer.
No, he will not file it now. We will not permit him to file it. Somebody else will file it. Who is so reckless and commits such error is not competent.
Secretary of the Health Department.
It's respondent number 1 and 2.
By
One
a
is-
high-ranking officer, right?
Additional Chief Secretary.
The learned counsel has submitted that an IA number 3143 of 24 has been filed for seeking 8 weeks time to file the required counter affidavit after completing the procedure. After hearing the learned counsel for the respondent and going through the interlocutory application, this court is of the considered view that correct facts are required to be brought on record by the respondents by verifying the record, and therefore the counter affidavit dated 2/5/23 and supplementary counter affidavit dated 12/9/23 filed on behalf of respondent number 3 is permitted to be withdrawn, though the same will is permitted to be withdrawn, and accordingly IA number 3155 of 2024 is allowed. Record पे ही रहेगा. Withdrawn and not to be pressed by the respondents. So far as IA number 3143 of 24 is concerned, it was filed on 18/3/2024. And accordingly, time till 8th of May.
Okay.
Time till 16th of May. 16th May, 2 महीना हो गया. 16th of May is granted to the respondents to file the fresh counter affidavit. The counter affidavit should be sworn by the respondent number
2.
Respondent number 1 should be sworn by the respondent number 1. That's it.
Well, we should only one clear this thing. The status quo may be maintained because the
Notice
petition-
has gone to the private respondent.
There is no private respondent act.
You have
There is
private
There-
respondent.
respondent number 4.
Number 4, yes.
Let notice be issued to respond number 4. You have a rival claim.
No, the point is that the juniors are there, and I have been serving in charge basis of the head clerk relation.
You have
Now,
made party, you want notice to be issued.
not required because
Then you delete.
law points are there.
Then you delete.
I'll delete that relation. Only the locus may be like the status quo may maintain since
No, we can't do anything.
since the
You
junior-
want to retain respond number 4 or you want to delete it?
because anyways
I don't know because I'm just asking you. If you have a party, notice has to go. You cannot have a relief without notice.
Notice may be issued to respond.
Let notice be issued to respond number 4 for under speed post, for which requisites be filed by the petitioner by Monday. Post on argument time till 16th, no?
16th.
Post on 17th.
Only one prayer is there.
No
Election
no
number 6 is
interim
there.
relief at this
Election
stage.
number 6 is there, wherein
No
the
prayer at this stage. Let them file the counter.
I'm asking for just for stay because
No.
they are asking to give the charges for relation.
We'll see that later.
Because he has been in charge of head clerk since last 6 years.
No,
relation.
please hold on for some time.
Of the list.
Yeah, ये dispose of हो गए ना.
हाँ दोनों आइए disposed of.
Item 16 WPS 2062 of 2023.
Yes, petitioner.
Matter relates to compassionate appointment essentially. The claim of the petitioner for appointment on the post of the child constable Balarakshi has been
Date of death.
date of death, Your Lordship, 6/12/2010, Your Lordship.
What was your age? You are claiming compassion.
Yes, ma'am.
What was your age on 6/12/2010?
4.5 years, Your Lordship.
How can it be granted now?
Yes, Your Lordship.
How can this relief be granted to you?
Yes, Your Lordship. The claim for appointment on the post of a child constable is claiming on the basis of the police order 2009 of 88, Your Lordship. That has been annexed by the counter affidavit, Your Lordship. Kindly have a look to the counter affidavit dated 24/7/23, Your Lordship. There is a provision, Your Lordship. for-
There is the provision, there is no doubt.
Yes, Your Lordship.
But you cannot have it like this unless you were entitled for your
I
appointment.
was entitled, Your Lordship.
The minimum age is 12 years.
12 years, Your
Yes, so
Lordship. Your Lordship,
whenever you will attain 12 years, you will claim compassionate appointment.
That has been filed in the year 2014 itself, Your Lordship, by the
So-
grandfather of the petitioner, Your Lordship.
So
Your Lordship,
2014.
one thing I would like to mention, I have filed the rejoinder, Your Lordship, and brought on record, Your Lordship, 2 orders of the Bihar government, Your Lordship. Kindly have a
we
look.
are not
No,
in Bihar.
Your Lordship. We are following. Still, the Jharkhand state government is following the rule of Police Order 209 of 88, Your Lordship. Kindly have a look to that order. Page number 10 है counter affidavit, Your Lordship.
Look, what are you referring?
उसमें police order, Your Lordship. Counter affidavit, Your Lordship. The police order has been brought on record, Your Lordship.
You are arguing your case from the counter affidavit. Respondent is supporting you.
Lordship, police order was not available to me, Your Lordship. That's why, Your Lordship.
Yes. Annex page number 10.
Page number 10, Your Lordship.
Everything has been struck off in page number 10. Page number 9.
9 is different thing, Your Lordship.
Page number 10.
Page number 10, Your Lordship.
They have deleted everything here.
I have not deleted it.
They have deleted it.
Deleted.
Yes. Pura kata hua.
Your Lordship, counter affidavit dated 24/7/2023.
1/12/23. 24/7/23.
24/7/23.
10.
Yes, Your Lordship.
Yes.
May I read, Your Lordship? सरकार की सहमति के प्रत्येक जिला में स्वीकृत आरक्षी बल के 2 पद सुरक्षित रहने का आदेश दिया जाता है। इन पदों पर नियुक्ति की प्रक्रिया एवं शर्त निम्नलिखित होंगी। इन पदों पर 12 से 18 वर्ष के बच्चों की निम्न श्रेणी पर नियुक्ति की जाएगी। उन आरक्षी कर्मियों के बच्चों की नियुक्ति जिनके पिता माता निम्नलिखित दायित्वों का कर्तव्य का निर्वहन में अपनी जीवन अर्पित किए हैं की जाएगी। मुठभेड़ में, अपराधियों की गिरफ्तारी करने के क्रम में, अनुसंधान के क्रम में, सरकारी कार्य हेतु गंतव्य स्थान पर जाने के क्रम में, सेवा काल में स्वाभाविक मृत्यु हो जाने के फलस्वरूप। उपरोक्त श्रेणी में दीज आर द क्राइटेरिया और 2 ही क्राइटेरिया दिया गया है कि 12 से 18 वर्ष। उसमें कहीं नहीं लिखा गया है लॉर्डशिप कि विद इन 5 इयर्स आपको 12 से 18 वर्ष होना चाहिए, ये कहीं नहीं लिखा हुआ है। और स्पेसिफिक क्वेरी वाज मेड by the honorable coordinate bench of this honorable court that whether there is any notification or with regard to that within 5 years of the death of the father or mother whether that she has to attend 12 years old. Order dated 11/8/2023. और विद इन 5 इयर्स का जो ये क्लेम कर रहे हैं दैट इज द जनरल एडमिनिस्ट्रेशन प्रिंसिपल योर लॉर्डशिप। और जो ये सब
Where is that?
व्हाट योर लॉर्डशिप
Is there any impugned order?
yes your lordship impugned order annexure 7 your lordship page number 39 your lordship.
That's right.
May I read your lordship?
No, I've read it. ये जो 5 साल का कहानी है ना,
yes sir.
ये 2015 के सर्कुलर में।
ये सप्लीमेंट्री एफिडेविट्स फाइल किए हैं लॉर्डशिप। उसमें
अभी 15 से कॉल लिखा सर्कुलर में
है, बताइए।
92 के सर्कुलर में
92 के सर्कुलर
दिखाई जरा 92 का सर्कुलर।
95
वेरी सिट।
ये
पेज 30 सप्लीमेंट्री
सप्लीमेंट्री काउंटर एफिडेविट लगा
पेज 30
5 साल तक ही रहे।
अनुकंपा के आधार पर आशिक के द्वारा नियुक्ति होते आवेदन पसंद करने की समय सीमा में सरकार
ये आज भी बिहार का दिखा रहे हैं हम लोग। काइंडली हैव माय रिजॉइंडर योर लॉर्डशिप।
हम सुन लिए ना आपका, और कितना सुने बताइए।
रिजॉइंडर में एक बार डॉक्यूमेंट जो लगाए हैं उसको एक बार हमको केवल ड्रॉप कीजिए लॉर्डशिप।
आप इतना जो बोल रहे हैं, कोर्ट का ऑर्डर सब नहीं पढ़ते हैं। कोर्ट में जो ऑर्डर्स होता है, डेली ऑर्डर्स नहीं पढ़ते हैं आप लोग, उससे कोई मतलब नहीं। बताइए क्या इसमें दिखाना चाह रहे हैं।
पेज नंबर 9 योर लॉर्डशिप। माय रिजॉइंडर योर लॉर्डशिप।
बिहार सरकार
का ये आज भी तो उसी को फॉलो कर रहे हैं हम लोग। ये 92 का दिखा रहे हैं बिहार सरकार का ही, हम 2018 का दिखा रहे हैं और इसी चीज को क्लियरिफाई किया गया है। एक बार उसको केवल देख लिया जाएगा। निर्देशानुसार उपरोक्त विषय के प्रासंगिक पत्र के संबंध में कहना है कि बाल सिपाही के पद पर नियुक्ति संबंधी पुलिस आदेश संख्या 209/88 निर्गत है, जिसमें मृत पुलिसकर्मियों के नाबालिग बच्चों को बाल सिपाही के पद पर नियुक्त करने हेतु न्यूनतम उम्र सीमा 12 वर्ष निर्धारित है, किंतु पिता माता की मृत्यु के अधिकतम 5 वर्ष तक ही उनकी नियुक्ति की जा सकती है। ऐसा कोई नियम उक्त आदेश में नहीं है। आदेश में आवेदन देने के समय सीमा का भी उल्लेख नहीं है। ऐसे में पुलिस मुख्यालय द्वारा आलोच्य मामले में बाल सिपाही के पद पर नियुक्ति हेतु पुलिसकर्मी की मृत्यु की तिथि से 5 वर्ष की अवधि सीमा में ही बाल सिपाही के पद पर नियुक्ति हेतु उम्र की गणना संभवतः सामान्य प्रशासन विभाग के अनुकंपा नियुक्ति संबंधी परिपत्रों के आलोक में किया जा रहा है, परंतु बाल सिपाही पद पर नियुक्ति संबंधी पुलिस आदेश में ऐसा कोई प्रावधान नहीं है जिसमें यह उल्लेख हो कि बाल आरक्षियों की नियुक्ति के लिए आवेदन हेतु समान प्रशासन विभाग के अनुकंपा नियुक्ति परिपत्रों के प्रावधान लागू होंगे। अतः उक्त परिपत्रों के आधार पर बाल सिपाही की नियुक्ति में उम्र सीमा की गणना किए जाने का कोई वैधानिक आधार नजर नहीं आता है। बाल सिपाही के पद पर नियुक्ति संबंधी पुलिस
तब तो
आदेश
जिसका जन्म, अगर मान लीजिए कोई किसी का जन्म अभी होने में 5 दिन बाकी है, उसका भी राइट बन जाएगा।
5 दिन बाकी, ये
हाँ।
ऐसा क्लेम बोल रहे हैं जो कि इंसान के हाथ में तो है ही नहीं। एट द टाइम ऑफ डेथ
हम
और
सुन लिए
इसके नाम आता है ना पिता।
कंपैशनेट अपॉइंटमेंट का स्टोरी आपको पता होना चाहिए।
लॉर्डशिप
WPS नंबर 2062 of 2023। heard the learned counsel for the parties, this writ petition has been filed for the following relief. हम तो अभी तो जस्ट ही किए हैं, हमको याद नहीं है। लिखिए।
Prior to the
The
death
learned
of her
counsel for
father,
the
her
petitioner
mother was also.
has submitted that the father of the petitioner expired on 6/12/2010, and at that point of time the petitioner was 4.5 years of age. Since the father of the petitioner was working in the police department, therefore the petitioner was entitled to be appointed on compassionate ground as Bal Arakshi. He submits that for the purposes of appointment as Bal Arakshi, the minimum age is 12 years, and therefore, upon attaining 12 years of age, the petitioner should have been granted the compassionate appointment. The learned counsel submits that in the impugned order, a reference has been made that the impugned order has been passed by mentioning that the application for compassionate appointment has not been
filed within time.
though has been filed within time, but within 5 years from the date of death, the petitioner did not attain the age of 12 years, but there is no such provision of filing an application for compassionate appointment within a period of 5 years at the relevant point of time when the father of the petitioner had expired. The learned counsel has submitted that a letter dated 3/6/2019 issued by the state of Bihar has been annexed along with the rejoinder, and in the said letter also it has been mentioned that no time limit was prescribed for filing an application for grant of compassionate appointment in the case of Bal Arakshi. The learned counsel appearing on behalf of the respondents has submitted that the learned counsel has also referred to the circular dated 11/8/1988 to submit that in the said circular, which has been referred in the letter of state of Bihar dated 3/6/2019, no period of 5 years has been prescribed. The learned counsel for the state, while opposing the prayer of the petitioner, has submitted that a circular was issued by the state of Bihar कहाँ है? As नहीं, आपका सर्कुलर कहाँ है?
Supplementary counter affidavit dated Annex B.
Which has been annexed along with the supplementary counter affidavit dated 24/11/2023, Annexure B, which is dated 27th April 1995. And in paragraph 6, it has been specifically mentioned that in order to claim compassionate appointment, an application has to be filed within a period of 5 years. The learned counsel submits that the circulars which were issued by the state of Bihar prior to bifurcation continued to be operative in the state of Jharkhand till the new circular dated 1/12/2015 was was issued by the state of Jharkhand, and in that circular also there is a period of 5 years prescribed for applying for compassionate appointment. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, this court finds that it is not in dispute that the father of the petitioner had expired on 6/12/2010, and at that point of time the petitioner was 4.5 years of age. It further appears that an application for compassionate appointment was filed by the grandfather of the petitioner in the year 2014, but the same has been declined
In the year 2023.
in the year 2023 by the impugned order dated 18/2/2023.
That is the communication letter.
That's right. And has been communicated to the petitioner by the impugned order. It further appears that in the impugned order it has been mentioned that that even within 5 years of death of her father, the petitioner continued to be less than 12 years, and the claim of the petitioner has been declined. This court finds that the circular, that although in the letter number 209/88 dated 11/8/88 there is no period prescribed for making application for compassionate appointment, but at the same time, in terms of the circular issued by the state of Bihar, as back as on 27/4/1995, the period for making an application for compassionate appointment has been prescribed to be 5 years. Admittedly, even upon expiry of 5 years from the date of death of her father, the petitioner did not attain the age of 12 years. This court finds that the petitioner has not brought on record any scheme for compassionate appointment which entitled the petitioner to have a claim even when the petitioner was a minor at the time of, was much less than 12 years at the time of death of her father, and even within 5 years from the death of her father, she did not attain the age of 12 years to claim any appointment as Bal Arakshi. This court, in the judgment passed by the further no such provision has been placed on record by the petitioner in the form of any policy of the state that the claim for compassionate appointment will be kept pending till the minor child attains the age of 12 years, or that such a claim is to be considered once the child of ex-employee attains the age of 12 years. This court is of the considered view that merely because the Honorable Supreme Court, in a recent judgment passed by this court, in the recent judgment passed in the case of State of West Bengal versus Devrata Tiwari and others reported in 2023 Live Law SC 175, has summarized the principles to determine the claim of compassionate appointment. Paragraph 7.2 to 7.5 and 16.4 reads as follows. Note kar lijiyega. Considering the facts and circumstances of this case and the ratio of the judgment passed by the Honorable Supreme Court, this court is of the considered view that the petitioner is not entitled for compassionate appointment, as on the date of death of ex-employee she was just 4.5 years and was not entitled to be appointed even as Bal Arakshi. The claim of compassionate appointment is not a vested right which could be availed as and when the petitioner would attain the age of 12 years for being appointed as Bal Arakshi. This court, this view has, the similar view has been taken by this court in WPS number 1084 of 2023, decided on 1/3/2024. In view of the aforesaid facts and circumstances, the present petition is hereby dismissed.
Next, your lordship, one document in which Bihar government had stated this view, your lordship. उसी में लगा हुआ है कि
कुछ तो LPA के लिए भी छोड़ दिए, ठीक है। बिहार गवर्नमेंट का सर्कुलर हम लोग झारखंड में, बिहार गवर्नमेंट अगर कोई सर्कुलर निकाल देगा,
लेकिन फॉलो तो उसी को किया गया।
बिहार गवर्नमेंट अगर आपको बात समझ नहीं आती है तो इसमें हम कुछ नहीं कर सकते, राइट? If Bihar government issues a circular ignoring their own circular, we will also follow that. चलिए, call करें।
Item 17 WPS 2758 of 2023.
May I please mention? So this relates to appointment on the post of constable. I was not appointed, though I was in the zone of consideration within the merit
This
list.
advertisement was cancelled.
No,
No.
I was not appointed only on the ground that I have passed this matriculation, that is Pravesika from Hindi Vidyapit Deoghar. So it is not valid. Now the division bench of the Supreme Court considered that aspect and held there is an important judgment that the degree obtained up to 26 to 2015 is valid, and I have obtained this degree in 2012. So this was argued on the last date. This Supreme Court was pleased to direct them to say on oath before the Supreme Court as to what is the number of vacancies. If there is no vacancy, how can you be considered? So they have filed the affidavit and they have said that there are 17 vacancies in the district.
Arising out of the same advertisement.
Yes.
Arising out of the
Yes,
same
yes,
advertisement.
yes. Otherwise, how I will be entitled to? From
It
the
has
same
not been
agency.
advertised fresh,
Advertisement has been issued,
including these vacancies.
including these vacancies.
And that is also over.
No,
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 no, selection process is still going on, your lordship.
no, no. It is
What
just
is the matter
advertisement.
is, your lordship.
Where is that judgment?
My
Of division
judgment
bench.
is reported in.
नीचे जजमेंट देखिए, उसमें बहुत कैच है, इसीलिए पूछ रही
Yes,
हूँ।
the judgment
इसमें
is
एक और
2024-2022, volume 4.
दीजिए
JDC
जजमेंट, आप
page
देंगे
1.
नहीं, आप अपने पास रखेंगे, कैसे कर सकते हैं? आपने काउंटर एफिडेविट फाइल कर दिया?
हाँ,
पढ़िए।
Judgment. Para 23 one.
ऐसे नहीं पढ़ते हैं
23 में this is
ऐसे वन लाइन हम नहीं पढ़ते हैं, आपको पता है ना, हम ऐसे वन लाइन नहीं पढ़ते।
para 23 में है कि जज में डिग्री
भैया आप विद्वान हैं, हम आपके जैसा विद्वान नहीं, हमको पढ़ना पड़ता है। पढ़िए, कहाँ दूसरा कॉपी नहीं है? वेरी गुड, इसका तो हम कुछ कर ही नहीं सकते।
para 23. But I'm sorry for that. Para 23.
I can't do
Just
anything
your
about it.
lordship, ladyship may see para 23.
आपको क्या बोलना है?
इसमें एक वो है कि ये ऑर्डर was passed by the honorable division bench in May 2022, your lordship. On 10 Feb 2022, your lordship, and before that, the selection process was completed in year 2008.
Vacancy is there, no?
My lord, now the vacancy is not there. Vacancy is not there, and my lord, any order, if there would have been any interim order of this honorable court that the
There is no question of any interim
My-
order.
my
This
lord-
court has specifically pronounced that any degree obtained after 26 to 2015 would be invalid.
Would-
And this, the circulars of state of Bihar was already existing.
My lord, I am not on that point. Your Lordship. That degree
The
has been-
petitioner is on that.
My
You may not be.
my lord, the facts remain, Your Lordship, that the degree has been made valid up to 2015, Your Lordship. My lord, it is also admitted fact, Your Lordship, that the selection process was started, Your Lordship, in year 2015, and thereafter, Your Lordship, the same has been completed in year 2019. When the selection process was completed in year 2018, Your Lordship, 18-19, the degree in question was not valid. After completion of the selection process in 2018-19, Your Lordship, after 4 years, the degree has been made valid. Now the question would be, Your Lordship, whether on the strength of the order passed by this honorable court, a candidate can be ordered to be recommended in a selection process which has already been completed in the year 2018, Your Lordship.
He is
First
not
point.
claiming. He is not claiming on the strength of this particular
My lord,
order.
that is the fact, Your Lordship. If that is not case, Your Lordship, then I
He
am
is
out.
claiming on the basis of earlier circulars, which was discontinued with a particular date
My lord,
later on.
my lord, the facts remain that when the result was being published by the JPSC, the degree in question was not valid, Your Lordship.
By virtue of its circular.
By virtue of the circular issued by the state government, it was challenging that writ application, Your Lordship.
Which circular did it?
My lord.
आपके पास भी
हमारे
judgment.
पास हम
Do you want to say if the circular is held to be invalid, circular up to 2014 was there.
Huh.
If that circular was held to be invalid, the effect of the judgment will be prospective. There is no prospective overruling. There is
My lord,
nothing
my lord,
nothing prospective
I am
about
on,
it.
on slightly different way, Your Lordship. Your Lordship's query
आपके
is-
पास जजमेंट नहीं है, बिना जजमेंट देखे नहीं पढ़
इसको दूसरा दिन रखिए
कल रखेंगे ना, आप सुन लिया, बहुत सुन लिया.
क्योंकि इसमें 2018 के में at that point of time, Your Lordship, the order was the degree granted by the Hindi Vidyapeeth was held to be invalid by the state government. When the degree was held to be invalid by the state government, how we can consider, Your Lordship? First point. Then, Your Lordship, in 2022, Your Lordship, this honorable division bench of this honorable court had been pleased to pass order with the observation that the degree granted by the Hindi Vidyapeeth.
When was the result declared?
In 2017, Your Lordship. But
And-
I have mentioned.
And these writ petitions were pending prior to that.
My lord,
He
he
never
never
approached,
approached.
need
He
not.
never approached, Your
Need
Lordship.
Need not.
Read was pending,
Need
but
not.
no interim order was passed in the read. That the selection the ongoing selection process
When was his candidature rejected?
that was rejected in 2018.
Is there any order by which your candidature has been rejected?
My lord, I have
No,
indicated
no.
in my counter affidavit.
No order for rejection. They have said in counter that you were not having the valid certificate, therefore you were not considered.
और वही हमको करना भी था, because I can't go beyond the.
That's
I have to argue on to that extent.
Para 32 of the SSC counter rules.
ऐसा तो बहुत केस होगा, एक इकलौता केस थोड़ी.
My lord, some orders have been passed by this honorable court. In the cases when Your Lordship, after passing the order, Your Lordship, the selection process was completed. But that order has been challenged by the state government by way of the intra-court of India.
अब ये लोग तो जजमेंट ही नहीं है इनके पास पढ़ने के लिए, तो हम क्या पढ़ें? हमारा थोड़े काम में बैठ के पढ़ते रहेंगे.
हम
अपना
ले
आपको
आए
अपना दे दिया और हो गया
नहीं
बात.
तो हम ले आ जाते माइनर्स में सी पारा 23 हाँ
पढ़िए. सिर्फ पैरा 23 नहीं पढ़ेंगे, वो सर्कुलर दिखाइए, फैक्ट दिखाइए,
यस
फाइंडिंग दिखाइए, अंडर व्हाट सर्कमस्टांसेस इट हैज बीन सेलेक्टेड.
यस
My lord, ये para Your Lordship.
just one para before notes para 22 In view thereof, this court held that the degree of Pravesika, Sahit Bhushan and Sahit Alankar has got equivalence to the matriculation, intermediate and graduation as decided by letter dated 11/1/1991 by the Central Administrative Department, Government of Bihar, which was adopted by the state of Jharkhand, wide order dated 3/11/2003, and as such, the validity of order dated so and so will be effective up to 26/2/2015. The basis was that since you have taken this decision, so till that day you cannot say that yes, the earlier order were also, earlier certificates were also invalid. And
When was the selection process in this
Madam,
case
can you see
started?
your Lordship?
When was the
Please.
selection process
50,
started?
2015.
Date.
My lord, it is August 2015. Advertisement number 4 of 2015. The last date of the submission of the application form was up to 30th/9/2015, your lordship. And at that point of time, the degree in question was already held not valid by the state government. That I have detailed in my counter.
कहाँ आप लिखें वैकेंसी है?
Manoj, sir, it is their counter, not the state's counter, which is filed pursuant to order of the Supreme Court on 14th of February 2023. They have filed.
Paragraph 6 and 7.
Yes.
Supplementary counter.
The last pleading was supplementary counterfeit filed by respondent number 3.
Paragraph 6 and 7.
6 and 7.
6 and 7.
And what's your lordship judgment is there just yesterday, 2/4/2024, considering this very advertisement, and your ladyship has said that even if advertisement 2023 has been issued, you cannot ignore his case and you consider.
That is your lordship termination. Termination में नहीं लगेगा.
Termination नहीं है.
टर्मिनेशन के आप जजमेंट पढ़े नहीं, टर्मिनेशन कर दी ना.
इन्हीं के केस का जजमेंट है, इनको खुद ही नहीं पता.
बता भाई दे देते हैं बस ऐसा कि एकदम क्या
नहीं, हम नहीं देंगे.
बड़ा मुश्किल हो जाता है.
इनको खुद ही नहीं पता एलपीए फाइल करना है इनको, लेकिन नहीं
नहीं,
पता.
अभी हम नहीं पढ़े.
उसके बाद लिमिटेशन के साथ फाइल करना.
For everything there is an argument, counter argument.
Yesterday it has been passed to Rocky. I have not gone through. Although I have downloaded it.
बहुत अच्छे ड्रॉअर में रखे रहिए.
असल में नहीं मिला कर रहा.
नहीं चलेगा आपका ये कहानी.
ठीक है.
आप बताइए, आप स्टेट
Yes,
अपोज कर रहे हैं पिटिशनर को.
My lordship, my only contention is that my lordship, he has opposed in year 2023, my lordship. Other persons, my lordship, who have challenged the my lordship notification whereby the degree of the Vidyapit has held invalid, my lordship, they have only opposed this court, my lordship. After that, they got a degree, my lordship. He is a fence sitter, my lordship, and after 4 years, he should have challenged a writ application, my lordship.
You did not declare his result at all.
Still,
Why didn't you declare his result? You should have declared him fail.
फेल का तो नहीं ना होता.
Fail या whatever.
नहीं रोल नहीं होता. फेल का नहीं.
Candidature should have been declined.
Declined. Then he was required to take information under the Right to Information Act.
No.
Under
You will not communicate that your candidature has been
My lord, it is
declined.
not, my lord, in any selection process, my lord, this is the precedent your lord, across India, your lordship. Because your lordship, the lakhs and lakhs candidates are appearing in the examination, your lordship, and as such, it is not possible to communicate each and every candidate reasons for
के पास
rejection.
एग्जाम लेने के अलावा तो कोई काम नहीं है ना कि लिटिगेशन के
नहीं,
काम.
मगर उसमें होता है क्या कि उसमें हम लोग मार्कशीट हम लोग अपलोड कर देते ईच एंड एवरी कैंडिडेट का, और उसमें रीजंस दिया रहता है. एंड नाउ दैट इज देयर ड्यूटी टू ये डाउनलोड दी मार्कशीट एंड टू चैलेंज दिस.
मेरिट में यहाँ कोई डाउट नहीं ना कि आई हैव, if that is the ground then no, only on the ground of certificate you have not considered.
Change of category.
आपका मेडिकल टेस्ट भी आप इनका कराए हैं, सभी तो किए हैं.
हाँ, मेडिकल टेस्ट तो हमको कराना ही था ना, मेडिकल टेस्ट तो हमको कराना ही था. And at the time of verification of the documents, it was found that his degree is not valid. That I have
So
detailed in
at
my.
the time of verification of document in 26/11/2016, are you not supposed to inform him that no, you are not, your document is invalid
No.
and therefore you will not be?
My lord, at the time of verification of the documents, that procedure is to be followed. Whether the caste certificate is valid, whether the educational certificate is valid, all are to be communicated and seen at the time of this.
So he was called for document verification
He
on
was
26/11/2016.
he was called
You did
and-
not communicate anything to him.
My lord, mark sheet was uploaded, your lordship.
What do
Must
you
be
want?
communicated.
We do not know. You tell us from the counter affidavit.
My lord, I have all
Must
the-
be, therefore it should have been.
Para 32 may kindly be seen, your lordship, of my counter affidavit.
Yes.
That has not been controverted by me, your lordship. Page 12. That is, in view of the aforesaid factors, JPSC has not considered the degree of pravesika granted by the Hindi Vidyapit Deoghar while preparing the final result, and as such candidature of
There
the
is no
petitioner was not considered by the JSC.
There is no communication regarding his, that you are declining his
He has
candidature.
admitted that, paragraph 12 minus of his writ application.
That's right, we have seen that. Still there are vacant posts to adjust.
As per my lordship, this advertisement of 2015 my lordship, there is no post vacant. Because
No.
same has been carried forward. Paragraph
Carry
6,
forward means what?
in
Not
the
yet
next-
filled
next-
up.
Next recruitment process
Very
they have been carried forward. Now in the
Very.
present 2015 advertisement, there is no vacancy.
But arising out of the same advertisement, all the positions were not filled, isn't it?
It's about that it will be carried forward in next.
That is the judgment of this court also, your lordship.
It will be
My
carried
lord, I have also filed the counter affidavit subject to your lordship consideration, your lordship, in which your lordship I have detailed. My lord, this candidate has submitted the application for Palamu, your lordship, Palamu district. In Palamu district, your lordship, under unreserved category, altogether 286 vacancies were there, your lordship, home guard category and non-home guard category, your lordship. And we have made recommendation to the extent of advertised post, your lordship. I have detailed.
Otherwise he was qualified. How much marks could he
My
fetch?
lord, that I will have to ascertain. That I
Because
will-
he was in reserved category,
No, unreserved.
unreserved category. Users tell us that how much would be his marks.
That I will have to take. And what was the last selected candidate?
If his candidature is taken to be matriculate, if his candidature is considered, what marks he would have obtained? That is fixed marks. You allocate fixed marks.
My lord, that is, my lord, only there is qualifying marks. Qualifying marks. If any candidate has secured the minimum qualifying marks, he will be in the merit list. And from the top of the list, your lordship, I will select the candidates, your lordship.
So
And
his
the marks
name is
secured by
also
the
will
last
also
select-
be there in the merit list.
He was in the merit list, and as such, he was called for the documents verification.
Okay. Okay, you just tell us what was the marks obtained by the last selected candidate in the general category. You applied under the general category?
Unreserved. My lord, second point would be, your lordship, my lord, he was all knowing this fact that my candidature has been rejected. That he had mentioned in paragraph 12 of the writ application that when I approached after the result, final result was published and he was not declared successful, then he approached the authorities and he was informed that since his degree of Pravesika is not valid and as such he has not been declared. My lord, it has been informed in 2018 and now in 2023, after passing the order by the division bench in 2022, he has approached the court. First point. My lord, the second point would be, your lordship, subject to your lordship consideration, that when we published the result, the degree in question was not valid. And as such, it can't be considered with retrospective
What is the
effect on.
date of publication of result?
My lord, that your lordship, I have indicated. I have indicated, your lordship. नहीं, वो supplementary component. immediately. My lord, 28/6/2018, that is para 16 of my counter affidavit, because the specific query was made by this honorable court that how many candidates I have recommended, your lordship. I have detailed, your lordship, that total 286 posts were there, your lordship, and we made recommendation against 286 posts. My lord, can you see the para 16 of the supplementary counter affidavit?
You give the data with regard to last selected candidate
My lord, I will
and
give
his
your-
marks.
My lord, I will give your lordship. And third would be your
The
lordship.
learned counsel for the parties are present. The learned counsel for the petitioner submits that the petitioner has not been declared successful only on account of the fact that the petitioner was holding the matriculation or holding the certificate of Sahitya
Pravesh-
Alankar
Praveshika. Praveshika.
of Praveshika from Hindi Vidyapit Devghar. The learned counsel has relied upon the judgment passed by this court reported in 2022 within bracket 4 JBCJ 1 para number 23 to submit that it has been ultimately held that the degree issued by Hindi Vidyapit Devghar are valid up to the degrees issued by Hindi Vidyapit Devghar are valid up to 26/2/2015. The learned counsel submits that the petitioner has the required degree issued prior to 26/2/2015. The learned counsel for the respondents has submitted that on the day when the result was published, the degree was not valid in view of the circular issued by the state government, which was ultimately set aside by the aforesaid judgment. The learned counsel has also submitted that the result was declared way back in the year 2018 and the petitioner approached this court only in the year 2023, and therefore also the petitioner is not entitled to any relief. The counsel for the state has supported the arguments of the JPSC and has also submitted that pursuant to order passed by this court, supplementary counter affidavit has been filed by indicating that the vacancies which were advertised pursuant to the advertisement advertised by the advertisement involved in the present case have not been fully filled. However, they have been advertised they have been included in the fresh advertisement issued in the year 2023, and the recruitment thereafter has not been finalized.
And they have
Final
said,
तो नहीं हुआ ना अभी तक,
नहीं अभी तक recruitment नहीं हुआ.
and they have said that 17 posts are vacant
and it has been stated that 17 posts are vacant
in the district of Palam.
in the district of Palamu. The learned counsel for JPSC has also
JSSC.
JSSC. Like the learned counsel for JSSC is directed to file a supplementary counter affidavit indicating the marks of the last selected candidate under
Undeserved.
unreserved category
Within
as
bracket home guard quota.
home guard,
Quota.
within bracket home guard quota in which the petitioner had applied,
And also the marks obtained by this
My lord,
person.
there is
and also the marks obtained by the petitioner. How much time do you need? 3 weeks. मतलब कुछ बोलने के पहले सोचते नहीं
So
है.
3 days he was saying. No?
3 days.
that is his interpretation. My lord, he can say the no now. It is not Supreme Court. It is
Post
lower
this
court.
case
That's
on 16th of April. The supplementary counter affidavit should be filed by 9th of April. 9th नहीं,
9th.
15 तारीख, by 15th of April.
वो रिकॉर्ड सब लेना होगा हम लोग को। अभी वहाँ पर वो पेपर लीक हुआ है, सारा इन्वेस्टिगेशन के कारण सारा
बहुत सही हो रहा है।
नहीं तो वो तो सेंटर से होगा, उसमें हम लोग को थोड़ा ना करना है। दैट इज द ड्यूटी ऑफ द
अच्छा,
एडमिनिस्ट्रेशन।
आप 22 तारीख तक फाइल कर
जी
दीजिए,
जी
23 को करते हैं।
हाँ ठीक है, 22 तक फाइल।
Your case will be further argued only if you have secured more marks.
और
Otherwise,
secondly और
otherwise how I
lordship,
do?
quota of the home guard category has already been filled up. Quota
आप
of
वो
the-
भी ले, वो
हाँ,
भी ला
हम बोले
दीजिए।
हम कर ये करेंगे।
आप बोल दीजिएगा आपको जो बोलना है।
That
We
has
do not
already
know.
been filled up.
We do not know quota of home guard category has been filled up or not.
That I have mentioned, Your Lordship. That I have mentioned. Paragraph 15 onwards.
That's right.
Item 18 WPS 2878 of 2023.
Yes, petitioner.
Petitioner filed this petition for releasing the half suspension amounts as well as punishment as held to petitioner page number 23. अतः प्रमाणित आरोपों के लिए आरोपी चालक हवलदार राजेश राम के 2 वर्षों की वेतन वृद्धि का समर्थन किया जाता है। इसका अमाउंट 3 कालाम के बराबर होगा, जिसका प्रभाव भविष्य की वेतन वृद्धियों पर नहीं पड़ेगा। निलंबन अवधि
Page number.
पेज नंबर 23।
You were subjected to disciplinary proceedings.
After suspension, my suspension I revoked. Thereafter, I have joined.
Now you have been punished also.
On that time,
You don't have an appeal against that.
my criminal case I.
Do you have an appeal or you don't have an appeal? Is it an appealable order? Blank का क्या बात? अपील है? नहीं है?
क्रिमिनल केस में मैं कुटल गया, हम लोग फिर से अपील कर रहे हैं।
इम्प्यून ऑर्डर के अगेंस्ट में अपील है कि नहीं है, ये खाली बताइए। Yes, respondent.
There are several allegations against the petitioner.
I just want to know, is it an appealable order?
Also, if you examine the order also, it is a
Annexure 1 is the impugn order.
Yes.
This is police department.
Police constable.
This is an appealable order. Go and file your appeal. Go and file your appeal. You will have an opportunity to place your judgment of acquittal also. What is the date of the impugn order?
date is 7/19.
Yes, sir. इसका है।
इसमें अपील फाइल कर लीजिए, इंस्ट्रक्शन ले लीजिए, अपील फाइल कर लीजिए। आप when is the order of acquittal?
हाँ, एक्विटल
Date.
डेट 21/11/2022।
आप इसमें इंस्ट्रक्शन ले लीजिए, अपील फाइल कर लीजिए, क्योंकि अपील में ना वो सारा कुछ देखेंगे भी। आप पूछ लीजिए, इट इज़ एन अपीलेबल ऑर्डर, आपको कुछ पता ही नहीं है। आइए जरा किसी विद्वान अधिवक्ता से पूछकर ये ऑर्डर अपीलेबल है कि नहीं। जाइए, हम लोग को तो लगता है अपीलेबल है। 15 मिनट में आइए।
Item 19 WPS 3218 of 2023.
Leadership, we seek short possible seniors in court number 8.
What is the matter? What is it?
Actually, there is a lady who is getting money after the death of her husband, but another lady is claiming that the lady who is claiming that the amount which is she is getting in her account is uh, she is not the authoritative person and she is illegally taking that amount. So she has filed this case.
Where is the bank? Bank is not a party. You are for the bank. You have filed your counter. Yes. Who is that lady? Notice has been issued to respond number 6. Which neighbor?
Leadership, I was aware of the facts, but I have not gone through it fully.
Then it comes to further petitioner seeks adjournment. Post tomorrow. कल नहीं कल नहीं हो सकता. Post on Tuesday in the supplementary course list.
Next week किया जाए हम following line one.
Tuesday supplementary course list. Next.
Item 20 WPS 3227 of 2023.
Yes, petitioner.
इसमें काउंटर फाइल करने के लिए बोला गया था 2 डेट 2 बार बोला गया अभी तक काउंटर
Why are you not filing counter affidavit in this case? Who was to file counter affidavit? FIR was also instituted against you. Yes? Respondent is absent. In spite of repeated orders passed by this court, no counter affidavit has been filed. Today, nobody is appearing on behalf of the respondents.
Allegation in this that the photo of the petitioner affixed on the application form and one Rahul Kumar appeared in height test. For this one FIR has been lodged, and in that case this petitioner was acquitted.
Since no counter affidavit has been filed, the matter is required to be decided on the basis of the materials available on record. Post this case under the heading of final disposal on Tuesday. Let a copy of this order be communicated to the learned Advocate General. ट्यूसडे को सुन लेंगे फाइनली. इस तरह का 2 ऑर्डर हम किए हैं, देख लीजिए. एक
Item 21 WBS P for 5/1/2023.
अपीलेबल है.
हाँ, उसमें लगाया है अपील का ऑर्डर. पेज 34
अपील किए
जहाँ
हैं कि
किए हैं उसी का ऑर्डर लगाया है.
अपील का ऑर्डर इज ऑल्सो अंडर चैलेंज.
हाँ, पेज 34. कल बारिश
कितना दिन में अपील फाइल की?
23
कितना डिले?
23 का ये ऑर्डर है.
कितना डिले है? हाउ मच इज द डिले?
10-23 का है और करेले में आई हुआ है 22 में 6-1-23 29-11-22 को डिप्यूटल हुए और ये फाइल किए 13-4-23 13-4-10-2-23 को.
It was a case of no evidence.
भी लगाए हुए हैं. रेजिस्ट्रेशन में लगा हुआ है. बोल दी पहचानने से भी मुकर गई और कहीं पेज नंबर 4 रेजिस्ट्रेशन शपथ मुख्य परीक्षा गवाही देने आई हूँ. 15 तारीख और 19 तारीख है. कोई घटना नहीं घटी थी. न्यायालय में बयान करने आई हूँ.
The victim was examined in the departmental proceeding. Yes or no?
Yes.
She was examined in the departmental proceeding and she supported the case. In the criminal case, she did not support.
क्रिमिनल के उसका गवाही हमने पसंद नहीं, आदमी नहीं था. बोली गवाही
नहीं,
लगाई.
और डिपार्टमेंटल प्रोसीडिंग में गवाही हुआ कि नहीं?
डिपार्टमेंटल में गवाही हुआ. इसलिए भी आया था.
Yes. Was she examined in the departmental proceeding? क्या नाम था उसका? Yes, respondent. Was she examined in the departmental proceeding? कुछ नहीं पता है, पढ़ते ही नहीं. इंक्वायरी रिपोर्ट कहाँ है? F
पेज 26 में मैं आदि कार्रवाई संख्या इतना चालक राजेश राम संचिका नाम पाया गया है कि उपचारी जब नवनिर्मित वाहिनी मुख्यालय शिला फातिमा में चालक कार्य करने के लिए नियुक्त थे, वो दिनांक 24/20/1/10 को बिना सूचना किसी कैंप से फरार हो गए थे, जिस संदर्भ में प्रभारी कंपनी समादेशक शिलाफारी का ज्ञापन उनके दफ्तर में संस्कृत किया गया था, जिसमें उल्लेख है कि अपचारी दिनांक 24/20 को न की सूचना व अनुमति के कैंप से बाहर चले गए। मेरा प्रबंधक द्वारा मैच का सामान लाने के लिए खोजबीन किया गया, परंतु वे कैंप में नहीं मिले। ये 17:30 को जो कैंप में उपस्थित हुए, उपस्थिति के संबंध में प्रभारी समादेशक के द्वारा पूछताछ किया गया तो उन्होंने बताया कि तबियत खराब था, दवा लेने के लिए गए थे। दोबारा ऐसी गलती नहीं करूँगा। अपचारी पुनः 1-10-20 को कैंप में उपस्थित हो गए। इनके
सिर्फ पुलिस ऑफिसर को एग्जामिन किए हैं, विक्टिम हैज नॉट अपीयर्ड. यस,
एग्जामिनेशन किया गया था, सारे के सारे डिपार्टमेंट के लोग थे।
सारे डिपार्टमेंट के लोग थे ना, विक्टिम वाज नॉट एग्जामिन्ड. देखिए सर, एपिलेट अथॉरिटी को बोल रहे हैं एग्जामिन करने के, राइट? WPS number 2878 of 2023. This writ petition has been filed for the following relief. The learned counsel for the petitioner submits that the petitioner was subjected to departmental. The petitioner was constable in Gumla under IRB-5 Camp Mukhyalay Dhurwa. At the time, and on that time, one FIR was lodged against the petitioner under section 452, 354 capital A of IPC and under section 4/6 of POCSO Act, and the petitioner was suspended by the respondents. The petitioner was subjected to departmental proceeding as well as criminal case arising out of the same incident. In the departmental proceeding, the petitioner was found guilty and was punished by withholding 3 increments as well as due amount of suspension period कहाँ है आपका ऑर्डर? आप ठीक से लिखे नहीं. The petitioner was found guilty and punishment was also imposed. The learned counsel submits that so far as the criminal case is concerned, the petitioner has been acquitted in connection with Gumla PS case number 351 of 2020 within brackets special POXO case number 31 of 2022. By judgment dated 29/11/2022. The learned counsel submits that against the judgment passed in the departmental proceeding dated 17/6/2021, the petitioner filed appeal but the appeal has been dismissed solely on the ground that it was barred by limitation. The learned counsel submits that since the criminal case as well as the departmental proceeding were arising out of the same incident, and the fact remains that the petitioner was acquitted in the criminal case subsequently, the appellate authority ought to have taken this aspect of the matter and should not have dismissed the appeal mechanically by stating it to be barred by limitation, and at least an opportunity should have been granted to the petitioner to explain the reasons for delay. The learned counsel submits that the appeal has been dismissed by order dated 5/4/2022. The learned counsel has also submitted that the acquittal in the criminal case has a direct bearing in the matter, and therefore, in order to secure the ends of justice, the appellate court be directed to look into the matter in the light of the judgment of acquittal which arises out of the same incident. That's it.
Also, punishment of sentence is also there also.
Whatever be the punishment, he was found guilty and punishment was there. The learned counsel, appearing on behalf of the respondents, though has opposed the prayer, but does not dispute the fact that arising out of the same incident, both departmental proceeding as well as the criminal case was instituted, and the petitioner has been acquitted in the criminal case. However, he submits that the impact of the acquittal in the criminal case has to be seen in the light of the fact as to whether the petitioner has been honorably acquitted or he has been just given a benefit of doubt. And other materials which are on record. After hearing the learned counsel for the parties and considering the facts and circumstances of this case, it appears that arising out of the same incident, a criminal case as well as departmental proceeding was initiated. The petitioner was found guilty in the departmental proceeding and was also punished by order contained in memo number 73 dated 17/6/2021. And in the criminal case, the petitioner has been acquitted by judgment dated 29/11/2022. It further appears that the petitioner filed appeal after acquittal in the criminal case, and the appeal has been dismissed by order dated 5/4/2022 on the ground that it is barred by limitation.
23
Sorry?
अपील 23 5/4/23
22 लिखा हुआ है. Page number 34, 5/4/22.
इकट्ठा हुआ है
23 है क्या?
तो 29, 11, 22 को तो इकट्ठा
हाँ
हुआ
हाँ 5/4/23 हो
3 हो
लेकिन ये गलत डेट लिखा हुआ है इसमें। There is no doubt that
10/2/23 को ये फाइल किया था वो ऑर्डर है
it was
Yeah,
filed
yeah.
on 10/2/23 and the
Yeah.
appeal has been dismissed by order dated 5/4/23. There is no doubt that so far as a criminal case is concerned, the same has to be examined in the light of the principles of preponderance of probability. And in the matter of criminal proceedings, the prosecution has to prove the case against the accused beyond all reasonable doubt. However, at the same time, the impact of acquittal in the criminal case in the departmental proceeding is also an important consideration, and particularly in a circumstances where both departmental proceeding and the criminal case arising out of the same incident. This court is of the considered view that the appellate authority, before refusing to entertain the appeal, before dismissing the appeal by on the ground of limitation, ought to have granted an opportunity to the petitioner to explain the delay in filing the appeal, and under such circumstances, no such opportunity having been granted to the petitioner, the impugned order passed by the appellate authority is hereby set aside so that the petitioner may file an appropriate petition explaining the delay in filing the appeal, and also in filing the appeal, this court is of the considered view that the consequence of acquittal of the petitioner in the criminal case is required to be considered by the appellate authority. एक judgment है, आप तो लाए नहीं हैं. In the light of the recent judgment of the Honorable Supreme Court, है ना? ला आप लेके आए हैं देखो. लाइए.
2024 volume page 65.
लाइए सर.
Yes, that is the decision.
I think this is by Honorable Justice Khanna. पढ़ के भूल जाओ. That's right.
I think that
यही. In the light of the judgment passed by the Honorable Supreme Court reported in
2024 volume
2024 within bracket 1 JBCJ 65 SC Ram Lal versus State of Rajasthan. ठीक, चलिए जजमेंट भी आपको दे दी. इसका जरा देख लीजिएगा साइटेशन. सिविल अपील नंबर 7935 of 2023. Judgment is dated 4/12/2023. चलिए. The appellate authority shall decide the appeal within a period of 4 months from the date of communication of this order. आप अपना एक टाइम फ्रेम आपको दे देंगे. The petitioner shall also file an application for condonation of deed.
May I enter the next case? It may be listed for the final disposal. 22. 20. Sorry.
इसी प्रिंसिपल पर है क्या? सेम
Same
प्रिंसिपल.
principle.
किताब लेके आए.
That is my argument because that which order has been passed today, that was passed by this honorable court on 2022, and they have passed the order, appellate order against that is
Serial number 33, I have mentioned that
so
matter.
that may be listed.
इतना सीनियर आप बोल रहे, हम तो भाग नहीं रहे, हम आपको आप हमको भागने देंगे भी. इसलिए प्लीज होता है. Yes, madam, what do you want?
Yeah, I want that serial number 22 if possible for final disposal. A date may be fixed.
Pleadings are complete.
Yes.
Everything is there on record.
Yes. Okay. Reinstated. Counter rejoinder.
The criminal case has been considered by the appellate authority and they have declined to give you the relief.
Yes. That is the case.
Lordship, matter here is they were filed the writ after the initial order in a departmental proceeding. He was proceeded. Another criminal case was also there. He was removed from service and he got all the retirement benefits. And thereafter he waited for 7 years. And thereafter, after acquittal, he filed the writ petition. Now he has already superannuated from service.
I have filed the writ petition. It was allowed with the direction to consider the matter and pass the appellate order, and that has been rejected. And my case is fully covered by the decision because on the same evidence and same annexure, same deposition, they have passed that. I am
When do you want?
I want that any date may be fixed in the next week for
Tuesday?
final disposal.
Tuesday?
Yes. Final disposal.
List of dates बना लिए, notes बना दीजिए. लिखिए. Mrs. M.M. Pal, senior advocate, submits that the petitioner was subjected to departmental proceeding as well as criminal case. And in the criminal case, the petitioner has been acquitted, but the acquittal of the petitioner has not been properly considered by the appellate authority, and therefore the present writ petition has been filed. The learned counsel appearing on behalf of the respondents has submitted that the petitioner, after dismissal in the after removal in the departmental proceeding, has duly accepted the same, and the terminal benefits was also paid. And after expiry of more than 7 years, when the petitioner was acquitted in the criminal case, he filed the appeal.
No, writ petition, earlier writ.
He filed the writ petition, and thereafter, pursuant to the order passed by the writ court, his appeal was considered.
No, Lordship, earlier also appeal was considered, it was rejected.
His appeal was reconsidered.
Yes.
His appeal was reconsidered. The learned counsel submits that the petitioner, having accepted the order of removal long back, is not entitled to any relief. The petitioner might have even attained the age of superannuation. Okay? The learned counsel for the petitioner in response has submitted that the order of acquittal has a bearing in the departmental proceeding, and the order has been passed pursuant to the order passed by this court, and therefore the plea of the respondents is not tenable in the eyes of law. She submits that even if the petitioner has attained the age of superannuation, thus he would be entitled for post-retirement benefits if appropriate relief is granted.
And other service benefits.
And other service benefits. Okay?
Yes.
Okay, post this case for final disposal on Tuesday. वो judgment का copy उसको रख लीजिएगा उसको.
Yes.
The leave of your lordship, if I can mention, serial number 33, my lords. This case was faced after I have mentioned the matter. It is an appointment matter. Pleadings are complete. Under non-para category, as a regular candidate, my candidature has been rejected. Your lordship has also pronounced some judgment with respect to that.
वो तो same कहानी है, DB वाला.
हाँ, तो DB 25 को शुरू हो रहा है, तो मेरा कैंडिडेचर इसलिए रिजेक्ट कर दिया.
DB 25 को शुरू हो रहा है मतलब.
Lords, the counselling is starting.
Counselling. तो same order करना है.
No, this is different case. My candidature was rejected on the ground that I have completed my intermediate as a regular candidate while working as a para teacher. However, I have applied under non-para category. So there are several judgments, including the judgment of your ladyship, which says that there is no illegality with respect to that if he has completed his intermediate. On that particular issue,
ये कौन सा order किया?
I have the compilation. There are several judgments, my lord. This is covered matter. This is a compilation. Your ladyship has
चलिए
ordered.
इनका केस कल ज़्यादा टाइम नहीं लेंगे ना?
5 minutes. Your
Respondent
ladyship has
कौन है?
covered all these
अरे
judgments.
हमको
Lord,
भूल
second
याद।
last judgment of my compilation is your ladyship judgment.
इतना हमको नहीं याद रहता है। Respondent कौन है?
Respondent Mr.
बुलाइए।
Suresh.
उनको खबर कर दीजिए। उनको दे दिए ना?
हाँ, एक सेट लाइन दे देंगे।
उनको दे दीजिए भाई, आज दे दीजिए। आज नहीं देंगे तो कल आपका केस
नहीं, आज ही दे देंगे। And your ladyship, I want to send this judgment of Supreme Court has been uploaded, my lords. So for
क्या किए हैं इसमें?
उसमें वही कि सीट्स अराउंड 4000 सीट्स है उनको भरने के लिए, एंड दूसरा कि कोई भी इशू है तो यू कैन गो टू द हाई कोर्ट विद रिस्पेक्ट टू एनी। आई फ्लैग दैट पर्टिकुलर पोर्शन ऑफ द फ्लैग किया।
इसको रख लें?
हाँ, रख ले, आप
ठीक है, इसको जरा देखिए, इसको दे दीजिए आप। ठीक है।